Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about recent policy changes and how USCIS is adjudicating cases. Specifically, within the last month, and one policy was issued just a couple of days ago, USCIS changed significantly as to how it's going to process cases in general. So first of all, there is a big shift in policy where USCIS is going to refer everybody who did not qualify for relief they applied for and at that time do not have legal status in the United States to the immigration court proceedings. Basically, USCIS is becoming an enforcement agency, almost replacing ICE. And it's a big concern because now every application that you file, you will need to prepare very well, because it's either you're going to win that application or you're going to be placed in removal proceedings, and by then your status expired. Second policy change that came just a couple of days ago is about how USCIS is going to process cases which they believe do not contain sufficient evidence. In the past, if a case is submitted without one or two pieces of evidence, USCIS usually would issue a request for more evidence or an RFE, and the person would have an opportunity to cure this defect or perceived by USCIS officers defect. Now, USCIS said that they will change that policy, and instead of asking an applicant to submit or supplement the record, they will just issue denials. Unfortunately, however, sometimes USCIS would ask for evidence that was submitted, but for some reason the evidence was found insufficient. For example, very often it happens with I-864 affidavits of support when somebody is being sponsored based on family, usually marriage basis. And I see a problem here where a case that is a good case can get denied without applicant's fault, and then the applicant will have no choice but either to pay for motion to reopen, which currently costs about $675, if I'm not mistaken, in filing fees, or will have to resubmit the case with all appropriate evidence or additional evidence, plus may face issues, plus may face an issue of being served with a notice to appear. There are two examples of cases where USCIS said that practice will be for sure implemented. It's I-864 affidavit of support issues and cases related to waivers. Very often, I-601A waiver, for example, is submitted, and the USCIS would ask for additional evidence to prove hardship. Now, instead of doing that, they would issue denial. So those are very important policy changes that now both lawyers and clients have to keep in mind when they're preparing applications for USCIS. Thank you.